Okay, Facebook. What's wrong with the monitor? Okay, just very close. Very close. Oh my gosh. What is wrong with Facebook on this unit? I just have to switch off that camera. Okay. Facebook. I've got multiple laptops. I've got multiple cameras.
I do.
That is working. Okay. Shut that down. Put this here. Okay. Okay, I think it's working. YouTube. What's up with YouTube? Oh, okay. Right. Okay. Go YouTube. My channel. Oh, YouTube. Okay. All right. I'm so sorry. I am so sorry. I did a very foolish thing. I changed my password on Facebook when Facebook told me there was suspicious activity and that I should change my password on Facebook. And when I did that, dominoes started falling in all directions, having to do with my camera app, YouTube. You don't care. You don't care about my sob story. But thank God, 43 minutes late, it's back up and running. I am so sorry to everybody. But if you'll bear with me, I'm going to teach the class. And I just apologize so much. But it's a really good daf today. Okay, so who's in the house? Yehudit in South Carolina. I feel so close to all of you who are still with me, despite these technical difficulties. Bill in Mid-Missouri, Melissa in Great Neck, Lorraine in Texas, Shandora in the Bronx, Yehudit at the FBI. No, it says Facebook is working. Joe in the Inland Empire, Sharon in New Jersey, Shtavit, I'm not sure how to say your name, in Dallas, and Belle in Texas. And the candle reminds me, Bill. Thank you. Whoops, here we go. The Yiddish word for what I am is verklempt. I am verklempt. Okay. And over YouTube is working. And so Franco in Trieste, Italy. Wow, middle of the night. Aoife in Florida. Marjorie in Georgia. Ilanit in Silver Spring. You guys are heroes. Thank you for bearing with me. Okay. And of course, like today was a day where I felt like I'm very prepared. I've got a great daf. There's a lot to cover. I need to move fast because there's so much. So let's do it. Okay, our daf today is page 29 here in Tractate Sanhedrin, the 24th volume of the Talmud. Continuing our discussion of Mishnah number 4 here in chapter 3, which we're going to complete quickly and then get into a fascinating Mishnah number 5. We're picking this up at the bottom of page 28b, where we were talking about witnesses, possibly judges, who are disqualified because they're either related to each other or they're related to one of the litigants. So to finish up that discussion, bottom of 28b, the Mishnah teaches that Rabbi Yehuda says, and that was a minority opinion, that if the witness married the daughter of one of the litigants, he is disqualified even if the daughter died, provided that he has children from her, right? So in other words, if one of the litigants brings in his son-in-law to be one of his witnesses, so the other litigant will object and say, you can't bring in your son-in-law to be a witness in your case. And the litigant says, well, tragically, my daughter is no longer with us, so he's no longer my son-in-law. Says Rabbi Yehuda, yes, but if this litigant has a grandchild, right, that before his daughter passed away, his daughter had a child with this man, the son-in-law, then it's like they're still related through that child, and the son-in-law, though he's no longer the son-in-law since technically the man's daughter died, still he would be disqualified from testifying. That's the opinion of Rabbi Yehuda. Rabbi Tanchum says that Rabbi Tavla says that Rabbi Baruna says that Rav says the law is in accordance with the opinion of Rabbi Yehuda. The son-in-law is still disqualified even though the litigant's daughter died. Rava says that Rav Nachman says the law is not in accordance with the opinion of Rabbi Yehuda. And likewise, Rabbi Bar Chana says that Rabbi Yochanan says the law is not in accordance with the opinion of Rabbi Yehuda. And that is correct. So if the litigant's daughter died, then his son-in-law, is no longer married, he's now the widower of that daughter who passed away, would be qualified to testify in the case involving his former father-in-law, even if he has a child, even if his child is the grandchild of that litigant. I got to say, instinctively, I like Rabbi Yehuda's view, but the law is not, according to Rabbi Yehuda. Now, there are those who teach this ruling of Rabba Bar Chana with regard to this baraisa. Rabbi Yosei HaGalili interpreted this verse, and you shall come to the priests, the Levites, and to the judge who will be in those days. That's Deuteronomy 17:9. Rabbi Yosei HaGalili asks, what is the meaning of the phrase, who will be in those days? But will it enter your mind that a person would go to a judge that was not in his days? This is good humor. The Torah says you will go to the judge who was the judge over you in those days. Says Rabbi Yosei Galili, in what days would you go if not in your days? So this phrase is available for interpretation. The Torah must be teaching something, because it could have just said, you shall go to the judge. What does it mean, the judge in those days? You can't time travel, so of course it's the judge in those days. So why does the Torah add this phrase? Rather, this is referring to one who was a relative of one of the litigants due to marriage and then became not related. Maybe this son-in-law, it's not that, the daughter tragically passed away, but they got a divorce. So he's no longer related to the litigant because he's no longer married to the man's daughter. The litigant can therefore come before him only in those days that they are not related, and not while they are still related, teaching that if whatever the relationship was that prevented him from testifying or appearing before him as a judge, if that relationship no longer exists, perhaps through death or divorce, then they're not related, and he's now qualified to appear before him as a judge or to testify as a witness. And it is with regard to this baraisa that Rabbi Bar Chana says that Rabbi Yochanan says the law is in accordance with the opinion of Rabbi Yosei HaGalili. The ruling is the same as in Rabbi Yochanan's aforementioned statement, i.e., a relative who became unrelated is fit to bear witness or to serve as a judge, but it was stated in a different context. Then the Gemara relates, the sons of the father-in-law of Mar Ukva. All right, let's unpack that. Mar Ukva, the exilarch, the leader of the Jewish community in Bavel, the Jewish community in Babylonia. Okay, very important person, like a king, really. And the exilarchs in Bavel had very good relationships with the kings of the Persian Empire, right? Very prominent personality, VIP. Okay, so what happens? The sons of the father-in-law of Mar Ukva. So Mar Ukva has a wife. Her father is his father-in-law. This father-in-law has sons. Well, that would be his wife's brother, right? So we're talking about his brother-in-law or brothers-in-law, right? So we're talking about Mar Ukva's brothers-in-law, the brothers of his wife, the sons of his father-in-law, okay? and they came before him for judgment. Can he judge a case where his brothers-in-law are litigants? Sounds like no, right? Mar Ukva said to them, I am disqualified from judging you. They said to Mar Ukva, what is your opinion according to which you disqualify yourself? Do you rule in accordance with the opinion of Rabbi Yehuda that since you have children, we are still relatives? I'm sorry, I skipped something. The sons of the father-in-law of Mar Ukva were relatives of his and became not related to him as Mar Ukva's wife, who was their sister, died. Okay, so they're no longer his brothers-in-law because his wife died. Now, they came before him for judgment. Mar Ukva said to them, I am disqualified from adjudicating for you. This would seem to contradict our halacha, which is not according to Rabbi Yehuda. Since the wife has died, he can judge them. So they said to Mar Ukva, what is your opinion according to which you disqualify yourself? Do you rule in accordance with the opinion of Rabbi Yehuda that since you have children, we are still relatives? Well, then we shall bring a letter from the west, meaning from Eretz Yisrael, where this ruling was clarified by Rabbi Yochanan that the law is not in accordance with Rabbi Yehuda. And Mar Ukva said to them, is that to say that I am stuck with you? That I am stuck to you with a kav of wax? I agree that we are not considered relatives. I am saying that I am disqualified from adjudicating for you only because you will not obey the verdict. And I do not wish to participate in such judgment. Right? He's saying they come to him for judgment because they expect to get a favorable ruling. And they're not going to get a favorable ruling from him because he understands the case. And he knows that if they don't get a favorable ruling, they consider themselves above the law, and he's not going to get involved with them. And that's what was going on there. New incident, and we are on page 29a. The Mishna teaches that according to Rabbi Yehuda, one who loves or one who hates one of the litigants is disqualified from bearing witness. One who loves one of the litigants, this is referring to his groomsmen. Now, this ends up being not the law, that with regard to witnesses, emotion that they may have displayed of love or hatred toward one of the litigants is not going to disqualify them from appearing as a witness. But according to the minority view, it would. So now we're examining the minority view. According to Rabbi Yehuda, one who loves or one who hates one of the litigants is disqualified from bearing witness. So according to Rabbi Yehuda, what does it mean, one who loves one of the litigants? One who loves one of the litigants, this is referring to his groomsmen, somebody who's in his wedding party. And the Gemara asks, and for how long is the groomsman disqualified? And Rabbi Abba says that Rabbi Yirmiyah says that Rav says throughout all of the 7 days of feasting. And the rabbis say, in the name of Rava, even from the first day after the wedding and onward, he is no longer disqualified. He is disqualified only on the wedding day itself. Okay, makes sense that your best man at your wedding, on the day of your wedding, cannot appear in a court case that you might convene during your wedding as a witness for or against you, in this case for you, because yeah, his testimony might be biased in your favor. But the day after the wedding, it's okay. He's disqualified only on the day of the wedding itself. Next subject, the Mishnah teaches, one who hates the litigant. Again, according to Rabbi Yehuda, who would disqualify one who hates the litigant from bearing witness against him. One who hates the litigant. This is referring to anyone who, out of enmity, did not speak with the litigant for 3 days. So the sages taught in a baraisa, this law is derived from the verse, and he was not his enemy, neither sought his harm. That's Numbers 35:23. That one about whom it can be stated, and he was not his enemy, can testify about him. And one who neither sought his harm can judge him. So the Gemara asks, okay, we found a source for the disqualification of one who hates. From where do we derive that one who loves is disqualified? So the Gemara answers that one should read into the verse like this. one about whom it can be stated, and he was not his enemy, nor one who loves him, can testify about him, and one who neither sought his harm nor his favor can judge him. So the Gemara asks, well, is one who loves written in the verse? How can the verse be read in this manner? Rather, the extension of the disqualification to one who loves him as well is based on logical reasoning. What is the reason an enemy is disqualified from bearing witness? It is because he feels a sense of aversion toward that individual and might testify falsely against him. A similar logic can be employed with regard to one who loves as well. He feels a sense of affinity toward that individual, and he might testify falsely on his behalf. And what do the rabbis who do not agree with Rabbi Yehuda, who say that a person who loves or hates a litigant can still testify in that case? How do they derive from this verse? And he was not his enemy and neither sought his harm. So the Gemara answers, one part of the verse is necessary for the law that a judge who loves or hates one of the litigants is disqualified. Here, while we have said that, for example, my brother cannot be a witness with me or against me. We cannot be brothers who testify as witnesses. We cannot join together to be witnesses if we are brothers. And if I'm a litigant in a case, my brother cannot be one of the witnesses testifying in that case, whether in my favor or against me, because he's my brother. And the same would apply that he can't be a judge. He can't be one of the judges who's going to rule in this case if he's my brother. So there, in terms of this relationship, prohibited relationship for witnessing or judging, it's the same whether we're talking about a witness or a judge. But with regard to this emotional state, one who loves or hates one of the litigants, as a witness, he can still appear despite that emotion. But as a judge, he may not. Different rule for judge versus witness. One who feels a strong love toward one of the litigants or a strong hate toward one of the litigants may not judge his case. Good rule. And what do we say? Right? That a judge who loves or hates one of the litigants is disqualified. The rabbis, the majority, agree with this halacha, as such a judge is naturally inclined to favor one of the litigants. Now, the other part of the verse is interpreted in accordance with that which is taught in a baraisa. Rabbi Yosei, the son of Rabbi Yehuda, says, with regard to the verse, and he was not his enemy, neither sought his harm, it is derived from here that two Torah scholars who hate each other cannot sit in judgment together as one. Because of their hatred, they will come to contradict each other's rulings unjustly. I think we can learn actually two things, and that concludes our discussion in Mishna number 4. But it makes me think two things. Number one, perfect, good logic. You don't want two judges who hate each other, who are going to be part of in a monetary case. What do we have? A panel of 3 judges. If 2 of the judges can't stand each other, then that is going to affect their deliberations and their ruling, and they might end up, feeling one way or another, or, applying the law in one way or another, not so much just based on the facts of the case and what's going on with the litigants, but just to disagree with this guy he can't stand. Frankly, it also makes me think, I would like to think that Torah scholars are above this. Now, we know that Torah scholars can get very angry and passionate with each other when they're trying to get to the kernel of truth in their legal rulings, right? That's passion. They can even yell at each other. That's different than hating each other. I would hope that Torah scholars are above hating each other. And if they do hate each other, maybe that's further evidence that they shouldn't be sitting in judgment until they work that out. That's my own idea. No source for that. Okay. And that concludes Mishnah number 4. Now, Mishnah number 5, here in chapter 3 of Tractate Sanhedrin. How do the judges examine the witnesses? Boom, take a step back. Big difference from every, court procedural, trial procedural movie you've ever seen based on the American jurisprudence system. What happens here when somebody is suing somebody or when the state is prosecuting a criminal defendant? What do you have? You have lawyers for each side, either a defense lawyer and a prosecutor or a plaintiff's lawyer and a defendant's lawyer. And who examines the witnesses? The lawyers, right? The attorneys, or if somebody represents himself, he can examine the witnesses. Not in a rabbinic court, not in a beis din. In a beis din, the judge examines the witnesses. I do believe that you might find that in some European countries. Somebody will let us know in the comments. But in America, right, it's the attorneys who examine the witnesses. The parties examine the witnesses. They examine and cross-examine, right? And somehow from the sort of aggressive examination, or if it's a friendly witness, right, then you examine him, and the cross-examination is contradictory and aggressive. Or, usually you call your own witnesses, so you call a friendly witness, and then the cross-examination is trying to get, to reveal if he's lying or not. But in a rabbinic court, all examination of the witnesses is done by the judge, or by the judges, right? By the judges on the panel. So keep that in mind. So, how do judges examine the witnesses? They bring them into a room in the courthouse and intimidate them so that they will speak only the truth. Not just the formulaic, will you speak the truth, the whole truth, and nothing but the truth to help you God? And, yeah, I will. No. You got to make them understand that they are right now part of a holy search for truth to create a just and righteous outcome. Highest possible stakes. No matter what the amount of money involved is, getting at the truth is a holy and righteous pursuit. And they have to impress that on the witnesses. And they take all the people, other than the judges, outside. So that, the audience, whatever you call the people who attend a trial, they take them all outside so that none of them should tell the other witnesses the questions that the judges ask and the answers that the first witness gives, so that they can't be coached to give similar answers, right? It's all done privately, the examination by the judges. And since the judges are going to be the ones making the decision, this does not create some kind of unfair bias. And they leave only the eldest of the witnesses to testify first, right? So the witnesses are going to testify in order of age, oldest first. And they say to him, to the witness, say how exactly you know that this litigant owes money to that litigant, as the plaintiff claims. Remember, we're in the section of Tractate Sanhedrin where we're talking about cases of monetary law. We are not talking about capital cases. Right now, we're talking about a panel of 3 judges that is judging a case of monetary law, like damages caused by an injury, or typical case, somebody lends money to another and wants to be paid back. Okay, so how do you know that you owe money? How do you say how exactly you know, you the witness, how do you know that this litigant owes money to that litigant, as the plaintiff claims? So if the witness said, well, the defendant said to me, it is true that I owe the plaintiff. Or if the witness says, so-and-so said to me that the defendant owes the plaintiff, then the witness has said nothing, and his testimony is disregarded. It is not valid testimony unless he says the defendant admitted in our presence, at least 2 witnesses, the pair of witnesses, we were both there, and the defendant admitted in our presence, not to us, he admitted in our presence to the plaintiff that he, the defendant, owes him, the plaintiff, an amount of money, for example, 200 dinars. So by admitting to the debt to the plaintiff in the presence of witnesses, that's how he renders himself liable to pay the amount that he mentioned. And afterward, they bring in the second witness and examine him in the same manner, that if their statements are found to be congruent, the judges then discuss the matter. Meaning if the two witnesses don't line up, if they contradict each other, there's no case here. The whole thing will be dismissed. If the opinions of the judges are then divided, as two judges say that according to the law in this situation, the defendant is exempt from payment, and one of the judges says he is liable to pay, well, then it's 2-1 and he's exempt. If two of the judges say he is liable and one says he's exempt, so he's liable because it's 2-1, he's liable. If one judge says he's liable and one judge says he's exempt, or even two of the judges deem him exempt, or two of them deem him liable, and the other one says, I don't know. So then the court must add more judges and then rule in accordance with the majority opinion. That's a surprise, right? If two say liable and one says exempt, okay, so he's liable, he has to pay. But if two judges say liable and the other judge says, I don't know, then we don't have a ruling. Then we have to add more judges until we get a majority ruling of judges who do know. Because the one who doesn't know, so then he couldn't contribute to the deliberations. So that's why we have to have judges who know the law, and then a majority of them issue a ruling. And this is because the one who abstains is considered as though he is not even a member of the court. So if it's two who say liable and one who says I don't know, it's like we only have two judges. After the judges finish the matter and reach a decision, they bring in the litigants. And the greatest of the judges says, so-and-so, you are exempt from paying. Or, so-and-so, you are liable to pay. And from where is it derived that when the judge leaves the courtroom, he may not say to the litigants or to one of the litigants, I deemed you exempt and my colleagues deemed you liable. But what can I do as my colleagues outnumbered me and consequently you were deemed liable? Judge can't say that. Can't say I would have ruled your way, but I was outvoted. He doesn't say that. Keep your mouth shut, judge. Why doesn't he say that? About this kind of a thing, it is stated, you shall not go as a talebearer among your people. Leviticus 19:16. And it further says in Proverbs 11:13, one who goes about as a talebearer reveals secrets, but one who is a faithful spirit conceals a matter. Right? Information on a need-to-know basis, especially that the litigants don't need to know which judges voted which way. None of their business. This would only create rancor in the community. And about that, the Torah says, don't go out as a talebearer among your people. Don't go out as a talebearer among your people. Likewise, don't be a gossip monger. Same idea. Now, Gemara on this Mishnah. The Mishnah teaches that the judges intimidate the witnesses in a positive way. So the Gemara asks, what do we say to them? What do we judges say to them? Rav Yehuda, not Rabbi Yehuda, Rav Yehuda, says that this is what we say to them. It is stated, quote, as clouds and wind without rain, so is he who boasts himself of a false gift. Proverbs 25:14. In other words, there will be no rain and no blessing from your deeds if you lie under oath. If you lie, period, but especially in a court of law. Rava said to him, if so, false witnesses can say to themselves that they don't have to worry about this punishment. According to the folks saying, 7 years there was a famine, but over the craftsman's door it did not pass. Meaning, famine really only affects the farmers in a very strong way, but a craftsman, his trade is more regular. So if he's not a farmer, what does he care whether it rains or not? Definitely a bad attitude. We're all linked to each other, especially in a primarily agrarian society like this was, to say, oh yeah, well, I'm not a farmer. I don't have to worry about that. But why would you be surprised by somebody who's going to also lie in court? They would also have, malicious and, false-based philosophies to justify his lies. All right? The Yetzer Hara is very strong, the evil inclination. People who want to lie for personal benefit will come up with all kinds of justifications why they should lie. What we want is that even somebody who is prone to lie, is willing to lie in court, would be dissuaded from doing that by this warning from the judges. So we haven't found a warning that we think will work yet. So rather, Rava said to him, this is what we say to them. Quote, as a hammer and a sword and a sharp arrow, so is a man who bears false witness against his neighbor. Meaning that a false witness will die prematurely. It's almost like it says, as a hammer and a sword and a sharp arrow, so is to a man who bears false witness. Doesn't say that, but that's the way they're interpreting it. Rav Ashi said to him, yeah, but here too false witnesses can say to themselves, the folks saying, 7 years there was a pestilence, but a man who has not reached his years did not die. Meaning everyone dies at his predestined time, therefore they will disregard this concern as well. Yeah, the evil force is strong with this person. So the Gemara presents another suggestion. Rather, Rav Ashi said that Nasan bar Marzutra said to me that we say to them that false witnesses are belittled even by those who hire them, and all the more so by others. As it is written that Jezebel said, when she ordered witnesses to be hired to testify falsely against Naboth, quote, and set 2 men, base fellows, before him and let them bear witness against him, saying, you cursed God and the king. That's from 1 Kings 21:10. So even Jezebel, who's one of the great wicked characters of the entire Bible, Lady Macbeth had nothing on Jezebel. Even Jezebel, who gave the orders to hire them, called them base fellows. So interesting that warning them that, yeah, you could die prematurely or you're going to lose all your money might not impress these guys enough that they would be unwilling to lie in court. But telling them that, yeah, the people that are hiring you to lie, they think you're scum. And how much more the rest of society if they knew what you were doing. And that this will actually be more effective. Interesting, because evil people often are ruled by their egos. Next subject. The Mishna teaches that if the witness said, the defendant said to me, it is true that I owe him, his testimony is disregarded unless he says, the defendant admitted in our presence to the plaintiff that he owes him 200 dinars. Right, so a witness can't come in and say, yeah, he said to me that that Reuven said to me that he owns Shimon 200 dinars. That witness has said nothing. It's only going to work when the witness can say, I was there, along with Levi, when Reuven said to Shimon, I owe you 200 dinars. And he and Levi can both back that up. Then that would be effective witness testimony to make Reuven liable to pay Shimon. But just Reuven saying, yeah, I owe him, that doesn't mean anything. The Gemara comments, and this supports the opinion of Rav Yehuda. As Rav Yehuda says that Rav says, the debtor needs to say to the witnesses, to the loan, or in his admission that he owes the creditor, you are my witnesses. Otherwise, their testimony is not valid. Not only did Reuven say to Shimon, in the presence of these witnesses, I owe you 200 dinars, but Reuven said to the witnesses, you are my witnesses when I say to Shimon, I owe you 200 dinars. Everybody knows what's going on. The witnesses are there to be witnesses. Reuven knows the witnesses are there. He admits to Shimon that he owes the 200 dinars in the presence of those witnesses. Otherwise, nothing's happened. And it was also stated that Rabbi Chiya bar Abba says, that Rabbi Yochanan says, if one said to another, I have 100 dinars in your possession, meaning you owe me 100 dinars, right? If I have 100 dinars in your possession, that's a way of saying you owe me 100 dinars. So I have 100 dinars in your possession. And the other one said to him, yeah. And the next day, the claimant said to him, okay, so give me the 100 dinars. And then the other one said, no, I was teasing you. I did not mean it seriously when I said that I owed it to you. The respondent is exempt, right? So I say to you, you owe me 100 dinars. And you're like, yeah. And then the next day I say, okay, so pay me the 100 dinars. And you're like, I don't know you anything, Sal. And I'll say, well, yesterday I said you owe me 100 dinars, and you say, yeah. And you could just say, yeah, I was just trying to get away from that conversation. I was just saying something. It doesn't mean that you said in front of witnesses explicitly that you owe me the 100 dinars or the 200 dinars, whatever the number I said. Now, this is also taught in a baraisa. If one said to another, I have 100 dinars in your possession, and the other said to him, yeah. And the next day, the claimant said to him, give it to me. If the other then said, I was teasing you, so the respondent is exempt. And moreover, the respondent is exempt even in a case where the claimant hid witnesses for the respondent behind the fence so that the respondent would not see them, and said to him, I have 100 dinars in your possession. And the respondent said to him, yeah. And the claimant then said to him, do you wish to admit the debt in the presence of so-and-so and so-and-so? And the respondent said to him, oh, I'm afraid to do that, lest you compel me to go to judgment, where based on the testimony of those two people, you will be given the right to forcibly take the money from me whenever you want. But between you and me, I admit that I owe you, right? The guy says, I do owe you, but I won't admit it in front of witnesses. But when he says that, there's two hidden witnesses hearing this whole conversation. So sounds like, well, then we have him, right? He said he would say it in front of witnesses, but he won't, because if he did say it in front of witnesses, then he'd have to pay. And that's the only reason he doesn't want to say it in front of witnesses. But he admits that he owes the money, and witnesses actually hear that. So doesn't he then have to pay? No. And the respondent said to him, and the next day the claimant said to him, so give me the 100 dinars that you admitted owing me. And the respondent said, I was teasing you. Even in this situation, the respondent is exempt because he can claim that he stated his admission only to appease the claimant temporarily, and he did not mean to actually admit to owing the money, as he did not know that there were witnesses present. He wasn't admitting it. He was just trying to get out of that conversation. And the reason he wouldn't admit it in front of witnesses is because he doesn't owe it, not because he'd then have to pay. But, very interesting statement. But the judges do not advance a claim on behalf of an inciter, i.e., one who is accused of inciting others to idol worship. Right? Avodah zarah, idol worship, idolatry, under Torah law is at the level of murder and rape. One of the top three sins. And how much worse, somebody, not just somebody who does idolatry, but somebody who leads other people who are proper, God-fearing Jews and incites them, cajoles them, manipulates them into becoming idolaters. One of the top sins that there is. Why are we talking about idolatry or someone who incites others to idolatry? We were talking about somebody who admits or doesn't admit that he owes money in a case of debt or other kinds of damages. So the Gemara asks, an inciter? Who mentioned anything about it? This matter was not discussed in the Baraisa. And the Gemara answers, the Baraisa is incomplete, and this is what it is teaching. If the defendant did not advance a claim that he was teasing the plaintiff, the judges do not advance this claim for him. So apparently, he stated his admission seriously. But in cases of capital law, even if the defendant did not advance any claim on his own behalf, the judges do advance the claim on his behalf, except in the case of an inciter. Okay, so I was reminded as I was reading this of, in our friendly poker game, sometimes the guys have been, it's late, we're tired, people have had a few beers. We're playing a more complicated poker game with 7 cards or something. And somebody, says, I have 3 of a kind. And the other guy says, or somebody says, I have somebody says I have 3 of a kind. No. Somebody says, one guy says why am I still messing this up? What I'm trying to say is somebody says, I have a straight. The other guy says, oh, I have a straight too. The first one says, yeah, but I have a straight to the ace. The other guy says, oh, my straight is only up, 10 high. I guess I lose. And the other guys at the table say, whoa, 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 whoa. You don't just have a straight, you have a flush. Your cards also have a flush there. A flush beats a straight. So the guy who thought he lost actually wins. He didn't even recognize the value of his own cards. But the rest of the table sort of acts like friendly judges who say to him, no, you have a better claim than you thought you did. You are actually the winner. And our rule at our table is the cards speak, right? So even though the guy didn't recognize that he had a better hand because he was tired or whatever, since he did have the cards, he's going to win the hand. Likewise here, that in a capital case where somebody has a defense that will get him off, right? It looks like he committed, murder or some high crime, and he doesn't realize that he has a valid defense and he would get off. So the judges say, no, you have a better defense than what you are offering to us, and we'll give it to you, and so you get off. Except in the case of an inciter. If somebody is inciting others to commit idolatry, avodah zarah, he has some kind of an excuse that would get him off. If he raised it, we don't raise it for him because that is such a heinous crime. And likewise here, somebody who admitted that he owes the money, but didn't admit it in front of witnesses, and now the next day the witnesses were hidden, and so the guy who is owed the money, the creditor, says, well, you admitted it yesterday. And the guy in court says, yeah, I did. I guess I have to pay. So we don't say to him, but you could just say you were teasing and you won't have to pay. Because if he really does owe and he's willing to pay, we're not going to get in the way of that. And that's why it's being compared to the case of the inciter. The Gemara asks, what is different about an inciter to avodah zarah that the court does not seek to deem him innocent? Rabbi Chama Bar Chanina, that we don't offer, if he has a defense, we don't tell him that he has that defense. So Rabbi Chama Bar Chanina says, I heard at the lecture of Rabbi Chia Bar Abba that an inciter is different. As the merciful one states concerning him in the Torah explicitly, neither shall you spare, neither shall you conceal him. That's Deuteronomy 13:9. So it is in this unique case of the inciter that the court is not required to try to deem him innocent. Rabbi Shmuel Bar Nachman says that Rabbi Yonasan says, from where is it derived that the judges do not advance a claim on behalf of an inciter? It is derived from the incident of the primordial snake, the snake in the Garden of Eden, who tempted Eve. He was the first inciter. As Rabbi Simlay says, the snake could have advanced many claims on its own behalf and escaped the punishment of going on its belly and eating dust all the days of its life. It had a valid defense. The snake, so he had many claims. And for what reason did the Holy One, blessed be he, not advance these claims on the snake's behalf? The Holy One knew that the snake could make these claims, but didn't inform the snake of that. That might have exempted it from punishment. And why did the Holy One not do that? Because the snake did not advance these claims itself. So we see that one who incites, if he can come up with his defense, okay, but we're not going to feed him his defense. And the Gemara asks, what could the snake have said? And the Gemara answers, the snake could have said that he is not to blame, as when there is a contradiction between the statement of the teacher and the statement of the student, whose statement should one listen to? One should listen to the statement of the teacher. Since God instructed Adam and Eve not to eat from the fruit of the tree of knowledge, Adam and Eve should have listened to God, not to the snake. Right? The snake could have said, why are they listening to me? I'm the student of God. God is the teacher. God told you not to eat it. What difference does it make what I said? He could have offered that as a defense. He didn't. Chizkiah says, from where is it derived that anyone who adds subtracts? This is a saying quite famous in the Talmudic world. Very good saying to remember. One who adds subtracts, right? One who adds to the law, like actually saying something that's not there, is subtracting from the law. One who is adding to the truth is subtracting from the truth. From where is this derived? As it is stated that Eve said to Adam, Eve said to the snake, right? When the snake said, well, what's going on? And she said, well, we're not allowed to eat any of this fruit. Well, why not? Because God has said, you shall not eat of it, neither shall you touch it. Did God say you shall not touch the fruit? No. Eve added that. Eve said, that God told us not to eat it and not to touch it. God never said don't touch it. When she added to the truth, that was the opening for the snake. In the Midrash, it says the snake then pushed her and she touched the fruit and she didn't die. And so the snake was able to say, you see, God said, don't touch it. You just touched it. Right? God said, don't eat it. Don't touch it or you'll die. Well, you just touched it. Did you die? No. So it's a lie. Not only can you touch it, you can eat it. And that's when she made the decision to eat it. And it's because she added to the truth. She added extra words that weren't there when God originally gave it over to her. Right? Whereas God had actually rendered prohibited only eating from the tree, but not touching it, as it is stated, but of the tree of knowledge of good and evil you shall not eat of it. Because Eve added that there was a prohibition against touching the tree, the snake showed her that touching it does not cause her to die, and she consequently sinned by eating from it as well. Rav Meharshia says that the idea that one who adds actually subtracts can also be proven from another source. Exodus 25:10, 2 cubits, amatayim, and a half shall be its length, right? This would be the measurement of the Ark of the Covenant. So without the letter aleph at the beginning of the word amatayim, it would be read matayim, which would mean 200 cubits. And the addition of the aleph, therefore, at the beginning of the word reduces the term from 200 to 2. Big subtraction through a little addition. Rav Ashi says another example in the verse in Exodus 26:7, Ashte Esrei, which means 11 curtains. Without the letter ayin at the beginning of the phrase, it would read Shtei Esrei, which means 12. Therefore, the additional letter ayin reduces the amount from 12 to 11. Abaye says, with regard to the case of one who denies a debt to which he admitted in the presence of hidden witnesses, the sages taught that he is exempt only in a case where he says, I was teasing you. But if he says, these matters never occurred, i.e., I never admitted to this, then the defendant assumes the presumptive status of one who falsely denies his debts, as the witnesses did hear him admit something. So consequently, he is not trusted to take an oath that he is exempt. When the guy said, yeah, I said that, but I was teasing you, he is exempt if he'll take an oath that he doesn't owe anything. But now he's not able to give an oath because he's lying altogether. We are on page 29b. The Rav Papa, the son of Rav Acha bar Ada, says, this is what we say in the name of Rava. The defendant is not rendered a liar because people do not remember all frivolous matters. Since the admission was not made seriously, I was just teasing you, I was just saying something to get out of the conversation, and that's something he might have forgotten. Doesn't mean he's a liar. Since the admission was not made seriously, perhaps the defendant forgot the incident. Therefore, his denial of it having occurred was not necessarily an outright lie, and he could still swear an oath that no, he doesn't owe the money. The Gemara relates, there was a certain man who hid witnesses in the canopy above his bed to hear the statement of another. And the certain man said to him, I have 100 dinars in your possession. So the other one said to him, yeah. And the claimant then said, let those awake and those asleep bear witness about you, hoping to induce him to agree to this testimony, as the respondent might assume that everyone was asleep. And the latter said to him, yeah, no, I don't swear that. When the matter came to court, Rav Kahana said, since he said no to him, his admission did not render him liable. The Gemara relates another incident. There was a certain man who hid witnesses in a grave to hear the statement of someone else, of his debtor. And the certain man said to him, I have 100 dinars in your possession. And the other one said, yeah. And the claimant then said, let the living and the dead bear witness about you. But then the respondent said no. And Rabbi Shimon said once he said no to him, his admission did not render him liable. And this makes sense. If you're saying, you owe me 100 dinars, and you're like, yeah, okay. And they say, let the living and dead in this cemetery bear witness. And you're like, yeah, no, I don't admit that in front of the living and the dead bearing witness against me, because you know that you don't owe. You don't admit that you owe. It's not that you're afraid you'll be forced to pay. It's that you don't believe you owe. You're willing to say, yeah, when it was just like, you knew you weren't going to have to pay and you just wanted to get away from here. But when it came to really seriously admitting it, you weren't willing to do that because you don't know. You shouldn't be teasing either, but that's a distinction we're making here. Ravina said, and some say Rav Papa said, conclude from it that with regard to that which Rav Yehuda says that Rav says, that one needs to say to the witnesses of the admission, you are my witnesses. There is no difference whether the debtor said it, and there's no difference whether the creditor said it, and the debtor remained silent. The inference is that the reason the sages deemed the purported debtor exempt in the above cases is that the debtor explicitly said, no, I do not agree that the living or dead or anyone around might bear witness that I owe the money. I do not agree to that. But had he remained silent, his admission would indeed have rendered him liable, since he admits that he owed money. There were witnesses there, even though he didn't see the witnesses. And then when the guy says, let any witnesses who might be anywhere bear witness if they hear this, and the guy says, yeah, no. But if he remained silent, then he would be liable. Now the Gemara relates, there was a certain man whom people called a kav of debts. A kav is a volume of measure, a measure volume. As everyone claimed debts from him. So he once said, who can claim debts from me other than so and so and so and so? I do not owe money to as many as people had. Everyone thinks that I owe money all around town. Actually, I owe money to Reuven and to Shimon. I don't owe money to anybody else. And he says that. Well, those whom he admitted that he owes, Reuven and Shimon, came and took him to judgment before Rav Nachman to claim what he owed them. Right? He said he only owes Reuven and Shimon, so at least pay Reuven and Shimon. Reuven and Shimon now want to get paid. And he then, in front of Rav Nachman, the judge, responded in the court that his admittance that he owes Reuven and Shimon was in jest. Rav Nachman said, a person is prone to make false statements so as not to make himself appear sated. Meaning, it is possible that he might say falsely in public that he owes money in order that he should not be considered wealthy. And therefore, as long as he has not made a proper admission that he owes a specific sum to a specific individual in front of witnesses, he is not liable. And the Gemara relates another story. There was a certain man whom people called a mouse that lies on dinars, as he was a miser who did not benefit from his money, like a mouse that sits and safeguards gold dinars. So the man said on his deathbed, so-and-so and so-and-so claimed dinars from me. And after he died, those guys, let's say Reuven and Shimon, they came and sued the heirs from the inheritance. They said, well, he admitted that he owes to Reuven and Shimon, so we want to get paid. They came to judgment before Rabbi Yishmael, the son of Rabbi Yosef. He said to them, when we say that a person is prone to make false statements so as not to make himself appear sated, right? He doesn't want people to think he's rich because then they're going to keep bothering him for loans or charity or whatever. Well, this statement applies to an admission during his lifetime. But after his death, in this case meaning on his deathbed, this does not apply. We assume that what somebody says on his deathbed is the truth. So the heirs paid half the amount of the claim. And the claimants then sued them for the other half. So they came to judgment before Rabbi Chia. Rabbi Chia said to them, just as a person is prone to make false statements so as not to make himself appear sated, so too a person is prone to make false statements so as not to make his sons appear sated. This guy doesn't want it known that his sons are now inheriting a large fortune because that'll be bad for his sons. And so he says, oh, no, I'm not rich. I owe money. Right? So one might claim falsely on his deathbed that he owes money so that his children will not be considered wealthy. Therefore, there is no room for a claim against the heirs. So the heirs then said to him, well, if so, let us go and overturn the former verdict and retrieve the half of these alleged debts that we already paid the claimants. And Rabbi Chiya said to them, well, not so fast. The elder, meaning Rabbi Yishmael, who oversaw the first case, he has already issued a ruling in this case, and it is not in my power to overturn his ruling. So the half you paid stays paid. If one made an admission in the presence of two witnesses that he owes money, and they performed a formal act of acquisition with him to verify the admission, the witnesses can write a record of the admission in a document and sign it, thereby granting the creditor more rights. But if they did not perform a formal act of acquisition, a kinyan, they may not write a record of the admission in a document, as the debtor presumably wants the loan to retain its status as a loan by oral agreement, which grants fewer rights to the creditor than a loan with a promissory note. If he made an admission in the presence of three witnesses and they did not perform a formal act of acquisition with him, Rav Ami says they can write a record of the admission in a document. Since the admission was made in the presence of three individuals who are considered a court, it is permitted for a court to write its verdicts. And Rav Asi says they may not write it in a document. Perhaps the debtor intended for them to serve only as witnesses, not as a court. There was an incident in which a person admitted his debt before three witnesses, and Rav was concerned for this opinion of Rav Asi, and he ruled that they may not write a record of his admission. So Rav Ada bar Ahava, I'm close to done. Questions or comments, please get them in now. I have to switch to my other computer. Just let me get that ready. Okay. What a day. Okay. So Rav Ada bar Ahava says, with regard to this document of admission, sometimes we write it and sometimes we do not write it. If the three witnesses were gathered and sitting when the debtor made his admission before them, so we do not write it, as perhaps he did not intend for them to serve as a court. But if the debtor gathered them, we write the document of admission, as the fact that he took care to bring three people and not just two proves that he intended for them to serve as a court rather than just witnesses. Rava says, even if he gathered them, we do not write it unless he says to them, be my judges. Be my judges and witness this admission and write it up as a verdict. As a court-approved document, as opposed to just witnesses who saw something. Mar bar Rav Ashi says, even if he says, be my judges, we do not write it, unless they establish a place for judgment and send messengers and summon him to court. Unless the entire procedure of an admission in court is implemented, the debtor may not have intended that they serve as a court with regard to this matter. If he made an admission with regard to movable property that he owes, and the witnesses performed a kinyan with him, so they can write a record of the admission in a document. But if they did not perform that kinyan, then they may not write a record of admission. But if he made an admission with regard to land, and they did not perform a kinyan with him, what is the law? Is it considered as though a kinyan was performed, as land is always available for collection? Ameimar says they may not write it. Mar Zutra says they may write it, and the law is that they may write it. And finally, Ravina happened to come to Damaria, and Rav Dimi bar Rav Huna of Damaria said to Ravina, if one makes an admission that he owes movable property that is extant, i.e. it is available to be taken immediately, then what is the law? Should it be considered like land, as it is similarly available for collection, and therefore the witnesses can write a record of his admission that he owes it? Is that the case? And Ravina said to him, it is considered like land. And Rav Ashi says, since it still lacks collection, i.e. it has not been physically transferred from one party to the other, it is not considered like land, and the witnesses may not write a record of the fact that he admitted that he owes it unless the debtor asks them to write it. That's where we'll knock off. Let me take a few quick questions. Again, I apologize for the terrible technical difficulties I had at the beginning that all spiraled out of control when I simply changed my password on Facebook to protect data. Okay, Joe, when a verdict is rendered, do the judges state it as one voice, or is the verdict stated as to who voted which way? No, that's why they say the leader of the court, the one who is most senior, he states what the verdict is, and they don't reveal which judge voted which way, and therefore that's why the judges don't reveal that after the fact. Bill, so in some civil law court systems, as opposed to the common law court systems that we have in the US and pretty much anywhere that was once part of the British Empire, the court will interrogate the witnesses. However, note the court and not the judge, because different civil law systems do it differently. The French method, I think, still has attorneys who do the interrogating rather than the judge himself. Elvis, Sal, you stole my thunder about the limits of impassioned disagreement between colleagues. Well done. We're starting to sync up. Very good. Bell, the judges ask the questions in state administrative and federal administration courts, and also all appellate courts in the U.S. Thank you, Bell. Excellent distinction. Just so. And of course, they ask very probing questions, right? And Aoife, clearly, Eve, right back to Adam and Eve, Eve believed that if she touched the fruit, she would die. She was not there when God gave the rule regarding the fruit. Eve must have gotten this addition to the law from Adam. In other words, Adam added to this law in God's name. Eve trusted her husband, who was with her when the snake, and did not correct her, and that's why she bit the fruit. Maybe. I haven't heard it put that way, but let's say you're right. Then Adam is still the one who added something that God had not said, and so the principle still holds. When we add to what is, what we think is there, we actually subtract from the truth. Right? When we add something and state it as the truth, when it's really just opinion, we are subtracting from the truth. That's what I've got for us today, and with God's help, we'll be together again tomorrow, Tuesday, God willing, at the regular time. I think I got the difficulties worked out. I'll certainly be setting up earlier to try to make sure, and I hope to be... Lately, I have been right on the dot, right? I really try to start exactly on time, and I hope I can again tomorrow at 6 p.m. Pacific. All the best, and thank you for being understanding.